case, recall the case, People versus Benjamin Detla.
After lobby for the people.
And on behalf of Mr. Dallas, please should be appeared by Zoom. Mr. Dallas, can you please state your name for the record?
Yes, Benjamin Dallas, Your Honor. Your Honor, maybe you go to the room first.
I'm sorry?
Can I go to a breakout room with my attorney?
Well, I can't put you in a breakout room where she is in person and you're not.
Then I can come see you after.
So after we're done, she's indicating she'll come see you.
Can I just talk to her real quick?
What?
Can I speak to her real quick?
You guys are in debt. You guys are very different.
Your Honor,
She's in the courtroom.
I know.
You're not.
Personal recognizance. Did you get my message about the personal recognizance bond, Stephanie?
I understand that you want to be released on bond, Mr. Dallas. Yes.
Yeah, the personal recognizance bond. That's all. That's all I wanted to say, Your Honor. I'm sorry. I apologize.
No, it's okay. It's okay. I get it. So what are we doing?
Thank you, Your Honor. Last week, the court was kind enough to forward me information regarding my client's current evaluation as the competency. And based on the document tendered to me on that day, signed by Andrea Zenbra, I believe, Mr. Detlef is not competent to stand trial, but they do believe he is likely to attain competency if provided the appropriate amount of treatment. Your Honor, we would stipulate to those findings.
People would also stipulate to the findings have no further evidence.
All right.
Yes, court signed any proposed order of continuing treatment.
Based upon a review of that report, the defendant at this time is incompetent to stand trial. I will set a competency review hearing May 22nd, 2025, 9 a.m.
Thank you, Your Honor.
Your Honor, and I believe the court has heard from my client where he is asking for a personal recognizance bond. I'm speaking to my client. He just wants to get out and start receiving some mental health treatment, and he is just asking the court's indulgence to allow him such treatment options.
Please, Your Honor.
Until something's in place, I'm not going to change the bond. This bond will continue. Once something's in place, I will be more than happy to look at it again.
Thank you, Your Honor.
Look into treatment for me. If I buy some treatment options for me.
Okay, what Mr. Detlef, what you're going to have to do is talk to your attorney about any requests that you're making, and they know the proper form to get it to me in. I'm not saying I won't look at it and won't release you, but there has to be something in place prior to my doing so.
Thank you, Your Honor.
Thank you. I'll make sure, Ms. Cannon, get those orders into me, please.
Yes, Your Honor.
Court does call the case of the People versus Marquise Hankey.
Alexander, on behalf of the people, Your Honor.
Good morning, y'all. Attorney Kevin Basant, P71061, on behalf of Mr. Marquise Hankey. Mr. Hankey, state your name for the record.
My name is Marquise Hankey. All right.
And Judge, we're asking for an adjournment. I just got substituted into this matter yesterday, Your Honor, and we're asking for an adjournment for discovery.
That's fine, appropriate.
Adjourned matter March 13th, 2025, 9 a.m. Yes, that's the bond.
Your Honor, I'm not sure, is the court in receipt of the bond violation report?
I am not.
I have not reviewed it either, Judge, but I'm certain what it would say. But
Your Honor, I have a report from February 24th of 2025 that the defendant had absconded from his tether and had been unable to be located. And they stopped supervision. I also wanted to address his jail before he got out.
Do we have that?
No, we do not.
And you're aware of this?
I am, Judge.
And I also want to address this jail calls from before he was released.
Yes, go ahead.
In those calls, the defendant contacts a third party who then contacts the victim. The defendant says, I need you to do me a favor. So you have that number right, and the person says, whose number? He does, who is the victim. He says, I can't say the name, I can't tell you, but I need you to do me a solid. He said, okay, what? Tell them I'm thinking of you. And he says, the defendant says, y'all been talking, right? He says, no, I've only been talking to Keita, who's the victim. He says, can't say that name on the phone, because she's my case. And then in the next call, the defendant gets her added to the call. He calls the third party who then connects her to the call, and they're talking. And I also have concerns that he would be contacting her at a different number because I had a note from Detective Mosher that he had been contacting her as well as a different number. I'm just not sure exactly what that number is. And given the facts of this case, I'm extremely concerned.
And may I address all those issues, Your Honor?
Yes.
And so briefly, Judge, my client
Just so
is
that I know, currently right now, he was ordered on a tether and he's not on a tether right now.
absolutely not, Judge, and I'll address it. So Judge, if I may, so Mr. Hankey, he's 22 years old, Judge, has no criminal history whatsoever. This is his first ever contact with the law. Literally, Judge, 3 days ago, he admittingly cut his tether off. He got overwhelmingly scared. He didn't understand what he was actually charged with. He thought he was charged with a life offense. I told him, no, it's a felonious assault. He was under the impression that he was immediately going to prison today because he didn't understand the law. And so he freaked out, Judge, and he indeed, admittingly, he cut his tether off. I immediately spoke with my client. I told him not to run, not to go anywhere, to address the court and to be upfront about it. And so, Judge, he's here today. He had every opportunity to not be here today, every opportunity to run, and he didn't. He takes full ownership for cutting that tether off, Judge. If I had talked to him before he did it, I don't think it would have ever happened. But Judge, I don't think he did it intentionally to, flee from the court. I believe he did it, honestly, Judge. And if hear me out, Judge, I think this is a situation, Your Honor, where fear got the best of him, anxiety got the best of him. In terms of the jail calls, Your Honor,
Do we have the tether back?
Your Honor, I'm not sure, but I did also want to address that the defendant does have a juvenile adjudication for a CSE fourth and a dismissed DV from 2022, which the victim failed to appear as well.
Judge, community corrections have the tether back, and there's been communications with the tether agent and the office. And so, Judge, in terms of the jail calls, I was just made aware of those this morning. I would note that his the complainant in this case is his girlfriend. She's currently pregnant. I told my client to have absolutely no contact with her whatsoever per the bond conditions. And so, Judge, I make this argument, Your Honor, because honestly, I'm asking the court if they would give him a second chance. There was a $70,000 cash surety bond. That bond was posted. But for his actions 3 days ago, Judge, we wouldn't have this bond violation, at least with the tether. With the phone calls, Judge, again, I'm not saying he admits or denies that, but he knows he's not to have any contact, third-party contact with the complainant, and that will continue. And so, Judge, I'm asking if my client could have a second chance on this tether. Again, Judge, he could have been like everyone else and just not come back or got caught.
We would have got him. I mean,
and you stole the words out of my mouth, Judge. I said, or he could be standing here today in a green jumpsuit, and he's not. He's here today, Judge, fully accountable for his actions. It won't happen again, Judge. I guarantee it. We plan to address this case, and I'm just asking for a second chance.
Counsel, go ahead, anything?
I just would kind of reiterate the facts of this case in which he pointed an AR-15 style rifle at the victim, saying to her, I'm going to kill you. I'll put a bullet in your head. And on the phone call, he addresses that he knows he's not supposed to be talking with her because when the other person says, Keita, who is the victim, he goes, don't mention her. She's my case. So I have great concerns that he would still be violent.
He's playing a game. I don't play games. We don't play games here. You don't get to be put on a tether. Well, first of all, be told that you should not be contacting the victim and then finding and manipulating ways to do so. Don't do it here. Doesn't happen. Won't happen. And then when you get the grace, given the nature of the charges, to get let out, then you're running around and you decide that what the court ordered in terms of a tether, you decide you want to cut it off yourself. We don't do that either. Defendant's bond is revoked, defendant's remanded. I'll see him on the 13th, and counsel, you can give me your argument as to what I should do with the bond at that point. But right now, he's remanded.
Thank you, Judge.
Thank you. Solani for the people.
Morning, Your Honor. May it please this honorable court, David Burgess on behalf of Brian Murphy, who's appearing, standing to my right.
Your name? Brian Murphy. Thank you.
Your Honor, we did receive discovery in this matter. We are requesting a preliminary exam in this matter.
People have their witnesses available the 11th.
We will try, Your Honor. I have not had recent contact with my police officers, as it appears that the person's been on bench warrant for a couple months, but we'll try for that date.
Preliminary examination in person, March 11th, 2025, 9 a.m. That's before Judge Washington.
Your Honor, may I address the issue of bond briefly?
Sure.
Thank you, Your Honor. Your Honor, my client did fail to appear. He was going to go to community corrections, and he knew he was going to test positive. He got scared. No excuse, Your Honor, but he did in the interim, Judge. He did reach out to me. I actually emailed the court to try to do a warrant recall. So he did make efforts he did retain counsel in this matter, but he did make efforts to come back to court to deal with this matter recently, Judge. I did not obviously get that. He was picked up in the interim before I received a response on the email, which was denied. But Your Honor, it's non-assaultive crime. There's no victim here. I'm asking the court. He has been in custody since last Sunday night, Judge. And I know he will appear for all future court dates, Judge.
Really?
Your Honor, may I respond?
You really know he's going to?
No, I don't think you need to, probably, but it's okay. Yeah.
No, that's fine. Go ahead, Mr.
He will,
I'll let you finish, and then I'll
All right.
hear.
Your Honor, and again, he was originally on a PR bond. I'm asking the court to at least consider a 10% bond. He's currently on remand, Your Honor.
And Your Honor, it does appear to me that at the time this case came up, the defendant had a tether on, and he had a violation with that tether because his battery had gotten too low. The police made contact with him. He had bench warrants for failing to appear, and a bench warrant for failing to appear on an assault battery. He had a bag of drugs on his person. It was just under a gram of cocaine, 0.88 grams of cocaine. He has a significant history for delivering or manufacturing narcotics. 2023, reckless. Looks like it was a fleeing third degree that was dismissed for fleeing. 2015, delivery, manufacturing narcotics. 2013, delivery, manufacturing narcotics, 5 counts. 2013, delivery, manufacturing narcotics, 2 counts. 2014, delivery, manufacturing narcotics. 2004, fleeing third. 2004, armed robbery, and assault with intent to rob while unarmed.
Yes, Mr. Griffin.
No, Your Honor.
Motion for bond reduction is denied. Bond will continue. Thank you.